First of all, I would like to thank each one of you for joining this International Virtual Summer School 2021. I feel extremely proud to say that this summer school has been organized by Nivaran, the mediators of Supreme Court of India. On this occasion, we are extremely honored to have Honorable the Chief Justice of India, N.V. Ramanna, and the guests of honor, Honorable Justice Vashisht Kokram, Judge, Appeal Court, Trinidad and Tobago, and Mr. Brian Spears, President, Commonwealth Lawyers Association, for the inaugural session. I bid a very warm welcome to all the guest speakers for the summer school who took out their valuable time and joined us today to be a part of this international virtual summer school. We are honored to have you all with us. We are thankful to the registered participants, lawyers, and law students for their enthusiasm and eagerness to gain knowledge and understand the concepts of mediation, which is being accepted globally. We are also thankful to our guests who have taken their time to attend this inaugural function. Nivaran, as the name suggests, means prevention, eradication, removal, which is similar to redress. Our aim is to share knowledge with regard to mediation, which is becoming a way of life. Nivaran has been conducting regular conferences, lecture series, and has chronicled huge success. Such schools enlighten the young minds and promote the participation of students at all levels. Regular lecture series usually help the students in inducing a thought for the global and domestic problems, which the world is sustaining. It would be our endeavor to help students understand the results of the human actions. It will focus on the major issues, solutions, and long-term effects associated with human activities. In addition to this, students will also learn about social skills. I would also like to offer my regards to all the people who made this virtual meet functional in such hard times. A special thanks to the Commonwealth Lawyers Association and to the Youth Bar Association in organizing the webinars and lecture series in association with Nivaran. Even though this summer school is a marker of the success of our institution, it also allows us to meet some of the brilliant minds of the country and internationally who have become the chief guests for this occasion. I guarantee that the summer school will be productive and worth your precious time. With all those words, I would now request Senior Advocate and Mediator of Supreme Court of India, Mr. Rajiv Datta, to give the welcome address. Over to you, sir.
Thank you, Ashaji. On behalf of Nivaran, Mediators of Supreme Court of India, I have the privilege to welcome the Honourable Chief Justice of India, Shri N.V. Ramanna, as our chief guest for today's inaugural ceremony of the International Virtual Mediation Summer School 2021. I also have the pleasure in welcoming our two esteemed guests of honor, Honorable Justice Vashisht Kokram, Judge Appeal Court, Trinidad and Tobago, and Mr. Brian Spears, President, Commonwealth Lawyers Association. Chief Justice of India, Justice N.V. Ramanna, began his law practice in the year 1983 in Andhra Pradesh High Court. On 7th of April 1988, he was appointed as the Advocate General of the state of Andhra Pradesh. Whereafter, he was appointed as permanent judge of the Andhra Pradesh High Court on 27th of June 2006. Thereafter, he was appointed as Acting Chief Justice of the Delhi High Court on 2nd of September 2013. He then became a judge of the Supreme Court of India on 17th of February 2014. He was appointed as Chief Justice of India on 24th of April 2021. After his appointment as the Chief Justice of India, we are experiencing a different Supreme Court, willing to stand by the citizens of India, be it issuing a notice to the Centre on the petition to quash British-era sedition law, or standing up for the rule of law as against the rule by law. While delivering the P.D. Desai Memorial Trust lecture on the 30th of June, he said, and I quote, "The move from a colonial past to present required a shift from colonial idea of laws imposed by foreign rulers for their benefit to laws given by our people to govern themselves laws which are not merely commands, but are also embodied by a sense of justice. Recently, while delivering his keynote address at the India-Singapore Mediation Summit 2021, he said, and I quote, "People are confident that they will get relief and justice from the judiciary. They know that when things go wrong, the judiciary will stand by them. The judiciary will stand by them." Very, very apt words for the Chief Justice to have communicated to the entire country. He further stressed on growing importance of mediation and promised that mediation holds as a tool of dispute resolution in India and Singapore. Chief Justice pointed out that India suffers from luxurious litigation syndrome. He qualified the benefits of mediation and imposed and impressed upon the rule of mediators and espoused for a stand-alone law for mediation in India. I recommend every mediator in India, especially the students of law and mediation, to listen to his full address and benefit from the same. Sir, you are welcome to this inaugural function. Let me also welcome to this inaugural function Honourable Justice Vishisht Kokaram, Judge of Appeal Court, Trinidad and Tobago. Justice Vishisht V. Kokaram was elevated to the Court of Appeal of Trinidad and Tobago in March 2020. Having already served as a judge of the Supreme Court for 11 years, he also served as a temporary judge of the High Court in 2006 on a backlog rendition project which he began with the use of mediation. He serves as a certified judicial settlement officer from the year 2009. Justice Kokaram was chairman of Mediation Board of Trinidad and Tobago from 2010 to 2018. He has led several public educational programs on mediation. He is a well-known community mediator under the Community Mediation Act from 1998 to 2005. He delivered the first lecture in our lecture series on the topic, the use of mediation skills in mainstream legal practice, the development of peace jurisprudence. You are, sir, very welcome to this inaugural function. Mr. Brian Spears is a council member of the Commonwealth Lawyers Association and also a member of its executive committee. He was elected as the president of the CLA in the year 2019 and is currently serving in the capacity as president of the CLA. In 2010-11, he had also served as president of Law Society of Northern Ireland. He is now its treasurer. He practices as a solicitor in Belfast, Northern Ireland, where he is the managing partner of CMG Cunningham Dickey Solicitors. He is not only the most experienced mediator in Ireland, but also in the entire European Union. He teaches ADR at the Institute of Professional Legal Studies at Queen's University, Belfast. He is a United Kingdom nominated mediation expert for many bar associations across Europe. Mr. Spears is very close to our heart as he was our first guest speaker in first international webinar and also delivered a lecture in the last year summer school organized by Nivaran. You are very welcome to the present inaugural function, sir. Back to you, Asha.
Thank you, sir, for welcoming our guests.
Asha, you are muted.
Thank you, sir, for welcoming our guests. Moving forward, I would now invite our guest of honor, Honorable Justice Vishisht Kokaram, Judge, Appeal Court, Trinidad and Tobago, to address the gathering. Earlier in our lecture series, we had the occasion to hear Honorable Justice Kokaram. We once again welcome you, sir. Over to you, sir.
Thank you, Ms. Neer, Asha, and Mr. Dutta Raji for that, for those kind words. Honorable Chief Justice of India, the President of the CLA, Mr. Spears, Brian, our good colleague, friends who are hosting the Varan Summer School for Mediation, colleagues, attorneys, peacemakers, all. good evening, good morning, good afternoon, wherever you are in the world. Um, I just would like to bring a few words of welcome to you all and congratulations to those of you of hosting this fantastic event. I would just like to share a brief story, if I may. Um, as a young lawyer, when I first came out to practice, I remember presenting my client's case um, to obtain an injunction, a mandatory order to demolish the gate and a fence of my neighbor, the neighbor of my client. The problem was my client lived side by side with his neighbor, and there was a common footpath leading up to their homes. The neighbor built a fence and a gate surrounding the entire compound, preventing my client from getting access to his own home. So I came armed to the teeth with the judge, and I pulled all the case law on trespass and rights of way. And I said, you know, we should demolish the entire gate and fence. I called the neighbor all sorts of names. He was a villain. He was a thief in the night. And I painted this horrible picture of the neighbor, even though they both were very close friends. I thought I was doing a very good job until the judge, who was an experienced mediator as well, turned to my client and asked, "Sir, what is it that you really want?" And he said, "Sir, all I want is a copy of the key so I can open the gate." Well, the matter was settled. I shrunk away from the bar table and disappeared into the black hole reserved for exasperated and miserable advocates. Now, there is undoubtedly a disconnect between the adversarial world, the adversarial model of lawyering, and the model of problem solving, which you will be introduced to in the summer school for mediation. Attorneys in the adversarial model remain transfixed on clients' legal position. They are argumentative to the extent of projecting their client's rage or to exact revenge. For instance, I've seen some lawyers in divorce cases so combative, you would think that it is the lawyers who are going through the divorce. These gladiator lawyers fail to disclose information that they may think will hurt their client, even though that information is helpful to find a just resolution. These gladiator lawyers will find any law to support a client's slimmest chance of victory and totally resistant to the idea of client-to-client communication. It's all about my client is right rather than how does my client feel. So I am happy that you have the summer school for mediation to train and to expose attorneys to a new way of thinking, to becoming part of the solution of getting to yes. You are the attorneys and the mediators who would help parties find the practical solutions, share information, allow clients to properly speak for themselves, manage emotions, and help plan a future without a life of conflict. And so it's in that context, I am so proud to see so many people. I think we've reached 401 participants so far, involved and excited about the program. And you are all commended for transforming the approach of the attorney from the adversarial model to the problem-solving model of dispute resolution. So I would like to end my short words of welcome with 3 points for you to take away in your summer school. Ponder on this. 1, think about transferring some of these mediation skills that you are about to learn into your mainstream legal practice. Mediation advocacy skills are not just confined to the mediation room. They are tools of problem solving. It is a new language which you can deploy in every stage of managing your client's dispute. Second, another major skill that you will acquire is not only the commitment to a consensual model of dispute resolution, but a deeper understanding and a display of emotional intelligence. And that is so important, to be aware of the social needs of your client, their realities, the underlying motives, their stresses, the emotions underlying their disputes. They are critical for you to plot and plan with them a future peace plan. And thirdly, remember your ethical codes. Your ethical codes as attorneys already require you to properly represent your client. Now, they demand that you sit with your client and with your opponents and together collaborate and plan for your mediations, your settlement discussions, and a plan for peace. Be inventive, be creative, think outside the box, help both the client and his opponent find a way out of difficult situations. So I hope in this lovely program that you're about to embark upon, that you become good mediation advocates, become active listeners. Don't be afraid to let your clients speak when you're in the mediation room. Do not underestimate the powers of emotional solutions such as apologies or expressions of regret. Encourage lateral thinking and creative solutions. Always be focused on the future and pay special attention, especially pay special attention to crafting durable, long-lasting, and workable solutions and agreements. Be good mediation advocates and be good advocates for mediation. So my congratulations to you all, students, and to all of those of you who have worked so hard to bring this summer school to fruition. And I hope that you transform the view of the advocate from this hired gun, this gladiator, to a peacemaker, a legal advisor. Continue to humanize the practice of the law. Thank you all. This morning, congratulations.
Thank you, sir, for your valuable contribution to mediation. I would now request our guest of honor, Mr. Brian Spears, President, Commonwealth Lawyers Association, to share his experiences in mediation. Over to you, sir.
Thank you very much, Asha. That was a lovely introduction. So far, so good, and what a treat to once again enjoy listening to Justice Kokaram. It's an honour to be present along with the Chief Justice, and I look very much, Chief Justice, forward to hearing your remarks, and have already noted the impact that you have made since your appointment. It's really lovely to be here with so many colleagues from India that I have become well acquainted with, some who have visited me in Belfast and some who I have visited through the medium of these webinars and participating in your summer school previously. So it is a huge delight to be among such wonderful colleagues, mostly from India, but across the Commonwealth. Aren't mediators just fantastic colleagues? They are patient, they are attentive, they are willing to explore your views with respect. And I've always found the company of mediator colleagues to be both inspirational and a tremendous learning experience. Justice Kokaram will remember giving a memorable address in Belfast at the end of 2019. And I can assure you, Vashish, that your remarks then were well received and impacted greatly on those who had the pleasure of hearing you speak in Belfast. Chief Justice, you will know that the mediators of the Supreme Court have made an impact, not just in India, but across the Commonwealth by their initiatives and leadership in promoting training, in promoting webinars, and in sharing their knowledge, and in questing for greater knowledge, understanding, and shared experiences. And their wisdom and erudition on the subject of mediation has been exemplary in my work within the Commonwealth Lawyers Association. I am very honoured and humbled to be the president of the Commonwealth Lawyers Association, a major force for upholding the rule of law throughout the Commonwealth. We have recently been alarmed by some challenges to the rule of law in the UK, in Lesotho, in more recently in Samoa, where there has been great disruption and disrespect for the judiciary in Samoa. And what we can do is call out examples where the rule of law is impacted adversely. And you, colleagues listening in, should take a moment to reflect on whether you would like to contribute to the work of the Commonwealth Lawyers Association in sharing best practice and in upholding the great qualities of the rule of law, independence and integrity of the judiciary and the legal profession, and freedom of expression. It is therefore from that organisation that it is my pleasure to bring this greeting and these words of encouragement to the Nivaran mediators of the Supreme Court of India Summer School. I went to New York in 1976 to attend a program on conflict resolution and mediation run by Fordham University. And it is right up there at the Lincoln Center for Performing Arts in the sort of Upper West Side of New York. And I was privileged to have received training from some of the best conflict resolvers on the East Coast of the United States. And the lessons that I learned 25 years ago have been applied, as Justice Kokharam has suggested. It is useful to apply in my day job, in dealing with clients and employees, and in dealing with colleagues. And the skills that mediation can bring to your whole worldview and your whole approach to collegiate working is something that I too commend. For the past 25 years, I have mediated a very wide variety of disputes and have taught mediation. I have been in tears as a result of participating in resolutions with emotionally charged situations and emotionally affected participants, from medical accidents resulting in harm and death to children and loved ones, to commercial disputes where you think emotion ought not to play a part, but really very often does. From defamation to government procurement, and yes, to property owner disputes, as Vashisht has shared his experience, neighbour disputes, rights of way, rights of landowners are fruitful areas where a mediation approach is beneficial. Mediation is challenging. It requires fluency of expression, attentive listening, sincerity, and to succeed requires the mediator to establish and retain the trust of all the parties and their representatives. And the mediator thereby can assist the parties to reach a solution that is better than the alternative, and to reach a solution that they can all live with. And mostly as a result, as you know, of a mediated solution, the parties adhere to that solution and implement it. So whether you are attending the summer school to learn to be a mediator or learn to advise clients within the mediation process, I commend you for your wisdom and foresight in taking part, in being open to learning new skills, to reinforcing already established skills. The CLA conference in Nassau, the Bahamas, will, we hope, take place in 6 weeks' time on the subject of sustainable justice, the future role of the lawyer. And to sustain justice, we need the independence of the judiciary and the legal profession. We need the integrity and ethical standards of the judiciary and the legal profession. And we need access to means of resolving disputes in a timely way, in an affordable way, and mediation can surely permit that. Only last week, the Master of the Rolls in the UK offered the view that mediation might become mandatory in certain circumstances. And it was in the case of Halsey against the Milton Keynes Health Trust that it was first mooted that mandatory mediation might offend against the human rights of parties to have a case heard by a court. Lord Justice Dyson, who gave the lead judgment in Halsey, was to speak at the inaugural Commonwealth Mediation Conference in Belfast in 2014. And some of you attended that conference and heard me read his words in which he remained of the view that mandating mediation was not on, that robust encouragement was the correct approach. Well, a report yesterday issued by the Civil Justice Council maybe has put paid to that and has introduced mandating mediation participation, but of course not mandating that people must agree within the mediation. The Singapore Convention has given international recognition and realism to the validity of mediation as a valid dispute option for commercial disputes. And the time is right for us all to embrace a problem-solving approach and a way of addressing difficult situations in a manner which meets the needs of the parties, addresses their concerns, meets their interests. And for that, I commend the work and leadership of the Nivaran mediators of the Supreme Court of India, and on behalf of the Commonwealth Lawyers Association, wish your program a tremendous success. Thank you.
Thank you, sir, for your encouraging words for the mediators of Supreme Court of India. It gives us a moral boosting for us, and sharing your experiences on mediation. Thank you so much. I would now invite Honorable the Chief Justice of India to release the newsletter of Nivaran, which covers its activities a little more than 1 year, and deliver his inaugural address and to declare open the Summer School 2021. Thank you, sir. We are honored.
Thank you. Can I go ahead with my speech?
Yes, sir. Sure, sir.
Dear brother and sister judges, Honorable Mr. Justice Aziz Kokaram, Judge of Court of Appeal, Trinidad and Tobago, Mr. Brain Spear, President of Commonwealth Lawyers Association, Santana Krishna, Organizer of Nivaran Mediators of Supreme Court of India, Mr. Rajiv Datta, Senior Advocate, Mr. Asha Nair, Gopal Nair, Advocate, Sudichi Agarwal, Advocate, other members of the bar, law students, Mr. Khanna and friends, friends from media, ladies and gentlemen. Namaskar. I don't want to say good evening, good afternoon. I want to say namaskar. At the outset, let me congratulate the Supreme Court trained mediators, Nivaran,
Thank you,
for
sir.
organizing this summer school on mediation for young lawyers and law students. I am delighted to be releasing the inaugural edition of the newsletter and inaugurating the present event for more than one reason. The first reason is that I believe that education is one of the most important tools to not only empower people, but to effect change in the society. To this extent, organizing an event such as the present one, where eminent mediators, lawyers, judges, and jurists have the opportunity to speak their thoughts on various topics and impart information and knowledge to foster new understanding among students and practitioners is invaluable. This brings me to the other reason. I am pleased to be inaugurating this event. I believe that mediation is one of the most important conflict resolution mechanisms currently, which will only continue to grow in relevance in the coming future. I recently had the opportunity of voicing my views on mediation and its growth in India, the role it can play in our country during the India-Singapore Mediation Summit. Mediation was a practice that was commonly followed in India prior to the arrival of the British and their court system. Not only did the British establish the framework for the modern Indian judicial system, but they were also instrumental in the creation of the myth that dispute resolution and justice requires black coats and gowns and elaborate arguments. It is time to dispel such myths and notions. The reality is most of the litigants in India suffer from many social and economic constraints. What they need is a quick, inexpensive, and convenient method of dispute resolution. Mediation is one of such mechanisms available to parties to a dispute which has the above mentioned characteristics. Apart from the fact that it is cost effective, time saving, and convenient to the parties, there is another facet of mediation that makes it out as perhaps better alternative for parties. Traditionally, litigation often leaves one of the parties to the proceedings dissatisfied with the result, which is why parties sometimes appeal decisions all the way to the Supreme Court. This often compounds the problem of judicial delays. This is an outcome of the winner takes all attitude that has come to affect the system. Mediation solves this problem. It signifies a shift from an adversarial attitude or position and creates an atmosphere that focuses on better outcome for all parties. It enables parties to contemplate a continued relationship after the end of the resolution process. An important facet of mediation is often not emphasized enough. It is possible contribution to improving access to justice in the country. Pursuing traditional litigation strategies can often be difficult for parties without ample resources or time or sophistication. Mediation is a tool of grievance redressal which is cheaper, faster, and simpler, can ensure just and fair outcome. The Supreme Court has played an active effort to improve mediation in India and has played a crucial role in bringing mediation into the mainstream. Various judicial pronouncements by the Supreme Court of India have, among the other things, resulted in the creation and spread of court-annexed mediation in the country. Apart from this, the Supreme Court Mediation and Conciliation Project Committee, which was set up in 2005, has been integral when it comes to the training of mediators in India. The first batch of mediators was trained nearly a decade ago, and first batch was trained in May 2019. I am glad to state that over the past 2 years, the Supreme Court trained mediators have been extremely active despite the ongoing pandemic and have organized various events, meetings, lectures, and discussions. The present summer school program is one such program which can help mediation become an important tool for Nivaran in the country. This brings to me the importance of the training of mediators. I had flagged some issues during the India-Singapore Mediation Summit regarding the difficulties that mediators face during conflict resolution. The first issue related to the role of a mediator, which is now shifting to more active, engaged role as opposed to the facilitative role which was earlier envisaged, and how a mediator must act in such situations. Second is what a mediator do or how neutral a mediator must be in the face of a patently unjust settlement reached between parties in unequal bargaining positions. Such issues requires a mediator to be well trained and equipped to understand and be prepared to react to any situation that arises before him. This can only happen if there is a well-designed training program for mediators in place with a focus on situation, recognition, and the appropriate response. The Supreme Court Mediation and Project Committee have already created a model training program wherein 40 hours of training and participation and successful completion of a certain number of mediations is a mandate for accreditation as a qualified mediator. However, it is necessary for the training program to be constantly updated and modified to keep up with the best practices in the rest of the world. Training should also take place periodically and continuously. We should also be innovative and think how new technologies and ideas can help in improving the training. As I have earlier suggested, the development of a training tool for mediators like the simulators used in the training of commercial pilots might be a useful innovation to put in place. It is also important that training take place periodically and continuously to keep mediators updated on the best practices to be followed. It must also be remembered, being a successful lawyer does not guarantee similar success in mediation. These two distinct roles, that is mediator and lawyer, requires it's a distinct characteristics. A mediator needs to be perceptive to the emotions of both the parties as well as the underlying issues. Even with the most stubborn parties, the mediator must guide parties with great optimism and patience to find a workable settlement. The role of law schools and law school curriculum should also not be underplayed. While the Bar Council of India mandate a course on alternative dispute resolution, more focus should be placed by law schools in the country on clinical education with a focus on mediation. The future belongs to the mediation. Law students and young lawyers need to learn the requisite skills and be at the forefront of creating the space for the establishment of the mediation and mediators as a separate profession. The court system needs full-time qualified mediators with necessary skills to convince parties to arrive at an amicable settlement. Going through the newsletter, I am incredibly pleased to see that since 2020, despite the pandemic, the mediators of the Supreme Court have successfully conducted multiple events with renowned speakers from across the world. All these events, along with today's program, are an important step towards the skill development of students and young lawyers. I am sure that the next week of lectures by all the eminent invitees will be an eye-opener and will make you appreciate, include, and improve mediation strategies while counseling present or future clients when they approach you with their disputes. Finally, I would again like to congratulate the organizers and wish them all the best for the success of this event. I thank Justice Vasis Kokaram, Judge of the Court of Appeal, Trinidad and Tobago, Mr. Brain Spear, President of the Commonwealth Lawyers Association, to participating in this event. Let me also formally extend my support for future events that they wish to organize. Let me conclude the words of the Mahatma Gandhi with the words of the Mahatma Gandhi. Finally, I quote, "I realized that the true function of a lawyer was to unite parties driven asunder. 20 years of my practice as a lawyer was occupied in bringing out parties, private compromise of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Thank you very much. I congratulate once again. Namaskar."
Thank you so much, sir. We are honored by your presence, sir. I now request Ms. Suruchi Agarwal, Senior Advocate and Mediator, to give her closing remarks. Over to you, Suruchi.
Thank you, Asha. Greetings to the distinguished guests, participants, and the law students as well as interns. Today, I have the very pleasant duty of giving my closing remarks to this inaugural session, and also to propose a vote of thanks to the Honourable the Chief Justice of India for sparing his time and gracing this occasion, and also to give such encouraging remarks on the activities of Nivaran. It is also my task and duty and pleasurable one to thank Mr. Brian Spears, the President of the Commonwealth Lawyers Association, as also Justice Vasisht Kokaram. I thank you all. We at Nivaran, Supreme Court mediators, are exuberant about this opportunity to interact with the young lawyers, interns, and the other participants through the summer school on the entire gamut of the process of mediation. The lectures will range from the historical background, introduction to mediation, conflict management, communication skills, negotiation ethics, online mediation, and the entire process of conducting mediation along with the current day challenges faced. We are of the belief that mediation has a pivotal role to play in reimagining legal practice away from dependence on adversarial frame of reference to a range of collaborative problem-solving options. Our distinguished guests are all one on this idea that we are in the need of a system and the need of the hour is to have the range of collaborative problem-solving options and to move away from the adversarial system. I'm not denigrating the lawyer's profession. I am one myself, and the skills that are required there. But I also advocate very strongly that we do need to move away only from the adversarial system. It is commonly said that business as usual in legal education, which remains largely geared towards traditional models of legal practice, that is, unyielding, lawyer-centric positional advocacy in a trial context, is rapidly becoming obsolete. The need of the hour is to rethink lawyer education in the light of these ideas and a call for the thoughtful and constructive redevelopment of new courses, curricula, and educational approaches to best prepare law students and lawyers for client-centered and resolution-oriented practice. This change of landscape in dispute resolution has prompted a number of law schools to incorporate a study of ADR as a component of existing substantive courses. It would not be long before law schools begin to offer ADR as a standalone course of study. I would here, with the permission of the panelists as well as the participants, share one experience. Justice Ramanna has said that the first course that was initiated by the MCPC was probably in 2010 when I joined and took the course, but of course I could not carry the practice of mediation. But I would like to just share that it is a life changer. A course on mediation can be a life changer for a lawyer as well as any other participant from any walk of life. The whole attitude to the approach to clients would change completely. And therefore, if we ask ourselves that in the presence of law schools, why is this initiative of taking forward the education on mediation by Nivaran, which according to us is a very exciting event, because to me, it is actually a life-changing event. So the answer to that question is that once you undertake the course on mediation, it changes you to deal with the clients as well as your life situations. And therefore, and as said by Justice Ramanna and the Honorable Chief Justice, that you need to incorporate and you need a continued practice of this. It is not only in law schools. You are gaining because the faculty, as I may call it, the guest speakers who are here to enlighten the students and participants, they would be enlightening them on various nuances of mediation, as I had said before. So therefore, I think it is very important that besides the law schools, Nivaran has undertaken this, and it is a great measure. So the teaching of ADR, and in particular mediation, in the legal curriculum can have a part to play, helping law students to understand a range of dispute resolution options in legal practice, readying them to play a non-adversarial role in mediation. If law students understand the theory and practice of ADR, they will be better prepared to advise their clients about the benefits of pursuing alternative options such as mediation. Mediation provides the opportunity for informal, flexible, and speedy resolution with the possibility of maintaining an ongoing relationship with the other party to a dispute, as has been stated by the Honorable Chief Justice. The adversarial form of justice is an unsuitable mechanism for the promotion of peace in communities and in our society. The adversarial system of justice serves, in most cases, to exploit the stresses in our communities and is in fact counterproductive to national development. With this, I would like to thank the Honorable Chief Justice. I would just like to say that in January 2020, the Apex Court in M.R. Krishnamurthy versus New India Assurance Limited pointed out the urgent need for enacting a uniform legislation for mediation. The Honorable CJI, in his keynote address at the India-Singapore Mediation Summit, Making Mediation Mainstream, and Reflections from India and Singapore, underscored the need for a law to make mediation the mandatory first step in dispute resolution process. As has also been highlighted by Mr. Brian Spears, that in UK there is a move to have pre-litigation mediation. So similarly, I think Justice Ramanna, we're very thankful that Justice Ramanna is supporting mediation wholeheartedly in this strong manner. An overreaching legislation would confer legal sanctity and provide procedural guidance to parties, as well as instill confidence in parties, as well as and to resolve their disputes through mediation. I would thank Justice Ramanna for declaring open and releasing the news letter of Nivaran, which is the first one that has been done. I also thank him for sparing his time to be present today to grace this occasion. And the highlights that I would take away is that the information and knowledge that would be imparted to the students in the mediation would be very important for the conflict resolution. And I think Justice Ramanna has said in a path-breaking manner that before the British had entered the country, India had the system of mediation, and it is not necessary to have black coats to have a justice delivery system, and a more cost-effective and easy accessibility to justice would be through the mediation process. So we are very grateful to the Honourable Chief Justice to be present and to give so many words of encouragement to Nivaran, as also to ensure and assure us with the continued support, which is, I would have in any case asked for that continued support, but the Honourable Chief Justice has already promised us, and it is very commendable for us that we should get the support in this manner. So thank you very much, sir. I would next like to thank Justice Vashisht Kokaram, he's a judge of appeal of Trinidad and Tobago, for sharing with us the path-breaking concept of peace jurisprudence, of which he is a pioneer, and which calls for a reinvention of the judicial process in form and substance, in which the principles of mediation are transfused, which is compassion, collaboration, and consensus. Deriving inspiration from Roger Fisher and William Urey's concept of getting to yes, the concept Justice Kokaram advocates is that the attorneys should be part of the solution to get to a yes. I could not agree more with the humanist approach to justice. The attorneys are to transform from adversarial to the problem-solving model of dispute resolution, and to help the parties find practical solutions, share information, allow clients to properly speak for themselves, manage clients to emotions, and help plan their future without a life of conflict. So I thank Justice Kokaram to be present here and sparing so much time. It has always been a pleasure, Justice Kokaram, and we really find your peace jurisprudence to be path-breaking. And the first lecture that was addressed, the first webinar that was addressed, really had an impact on us, as also today. And I cannot forget your concept of the winds of change blowing, and to change the entire scenario from an adversarial to a peacemaking and a peaceful coexistence kind of a concept. Thank you very much. I would now like to thank Mr. Brian Spears, the current president of the Commonwealth Lawyers Association, for also again sparing time to be present here, and also to offer such words of encouragement. We are indeed deeply, grateful to you, Mr. Spears, for encouraging Nivaran to the extent that you have today. I mean, and your words, I'll quote, that mediators of India have made an impact internationally and sharing their knowledge and their exemplary work. I mean, we are really grateful to you for having acknowledged this effort made by Nivaran. And also with a deep sense of appreciation for the work done by Commonwealth Lawyers Association in trying to uphold the rule of law and violation, and also to show a sense of, you see, not try, I mean, for the violation of law and disrespect for judiciary in UK, Lesotho and Samoa. I mean, we are all, as Supreme Court mediators, as also representatives of the Indian society, we are with you on that. I mean, we do acknowledge that Mr. Brian Spears is indeed a specialist in conflict management and is a great teacher, and for the past more than 3 decades, I think, and also that he has handled mediation pertaining to medical accidents, dealing with death and harm, and also commercial disputes, defamation to property disputes, and rights of landowners and neighborhood disputes. And we are very grateful to you for the guidance given to us as to the requirements of a mediator, namely the fluency of expression, the active listening, sincerity to retain trust of all the parties, to assist parties to reach a solution. And also for the fact that we do agree that the parties would definitely agree to adhere to such a solution that would come out from this mediation process. Of course, one of the very interesting points raised by Mr. Brian Spears is pertaining to, in the case of pre-litigation mediation, if there is a law to say that it is mandatory, we really welcome the question raised, and the challenge proposed is to constitutional rights. In case we do have a law of this kind to say that there should be mandatory pre-litigation mediation, it would certainly bring up the issue of the constitutional rights of the parties as to whether they can be forced under any constitution to first enter into a mediation. But I remember in a conference, Mr. Sriram Panchu once said that the answer to this question would be that the parties have a right to redressal of their grievance. It will not just be a question of their constitutional right. So in any manner, if their rights are redressed, is what would be the answer in my humble submission. So I really thank Mr. Brian Spears for his valuable time and to be here. Now, on behalf of Nivaran, I'm delighted to convey my deep sense of appreciation and gratitude to the guest speakers who are all acclaimed mediators and trainers for their enthusiastic support to this endeavor of Nivaran. I thank Mrs. Uma Ramanathan from Chennai, Mr. Sudhir Jain, District Judge, Delhi, Mr. Sunil Agarwal, District Judge, Delhi, Mrs. Sushila Sarathi, Senior Advocate, Bangalore, Mrs. Leila Olapalli, Bangalore, Mr. Yong Shi Kai from SIMC, Singapore, Ms. Gunawati from Malaysia, Mr. AJ Jawad from Chennai for sparing their valuable time for these lecture series and to agree to give lectures to the young lawyers, interns, and the participants. I thank Youth Bar Association for their continued support, and to Mr. Ajmani, who is the president thereof. The summer school, I'd just like to inform everyone that the summer school will not only be attended by interns and young lawyers, but senior lawyers and participants from all walks of life. I congratulate Team Nivaran, Mr. Santhan Krishnan, senior lawyer, and a guiding light for Nivaran, Mr. Rajiv Datta, Mr. Rakesh Khanna, Mr. Jitendra Mohan Sharma, senior advocates for their tireless efforts, and Mr. Rahul Kumar, a law student, for providing the technical support. And with these remarks, I have the great pleasure of thanking all the participants for being here for this inaugural ceremony. Thank you very much. And over to you, Asha.
Thank you so much, one and all, and looking forward for your active participation. Thank you so much.